The Supreme Court is set to take on a major case tomorrow. It could redefine the limits of judicial power. The policy in question involves birthright citizenship, but the heart of the case is whether a federal judge has the authority to block a president's executive orders. CBN's Brody Carter explains how the court's ruling could reshape presidential powers for years to come.
People that come into our country and they walk in and all of a sudden they become citizens and they pay a lot of money to different cartels and others.
In early 2025, President Trump signed an executive order aimed at ending birthright citizenship for children born in the U.S. to non-citizen parents. In response, Washington State's Attorney General and 3 other states sued the Trump administration.
We do not have a king. We have a president who must abide by the laws. And if they want to amend the Constitution, there is a process by which to do that.
And at least 4 federal judges blocked the president's order, issuing preliminary injunctions that put the move on hold while legal challenges played out. But the Supreme Court isn't weighing in on the policy of birthright citizenship itself, at least not yet. Instead, the president's lawyers have asked the justices to decide whether an individual federal judge should have the power to freeze a federal policy nationwide. A decision that could redefine the balance between the executive branch and the judiciary.
Sometimes you do want nationwide injunctions. For example, if there's an immigration policy, you can't have different standards being applied depending on whether someone flies into JFK Airport in New York versus LAX in California. But there have to be procedures in place so that the appeal to the Federal Circuit Court goes up very quickly.
Ilya Shapiro, director of constitutional studies with the Manhattan Institute, says the case could redefine how national policies are challenged in court and how much power a single judge should have.
People are saying now that the most powerful office in the federal government is that of a district judge.
Justices Clarence Thomas and Neil Gorsuch have called nationwide injunctions legally and historically dubious. And while critics call it judicial overreach, Mike Fox with the Cato Institute says this is exactly what the courts are supposed to do.
But, the idea that courts can't issue nationwide injunctions is just ridiculous. And if you're going to say that the rulings can only be confined to the parties or confined to a specific jurisdiction, you're dramatically increasing the amount of litigation. You're also, making inconsistencies across the board. I don't really see how that benefits anyone. At the end of the day, the law is the law.
Paul Larkin with the Heritage Foundation disagrees, saying federal judges exceed their constitutional authority when one district court can halt national policy. He questions whether a single judge should hold that much power and says this case could mark a turning point in rebalancing the branches of government.
Yes, a nationwide injunction issued by one judge has the benefit of trying to resolve an issue quickly. But that short-run benefit is greatly outweighed by the long-run benefit of making sure we get it done not quickly, but correctly, or to the best of our ability.
As justices hear oral arguments, legal experts are watching to see if the court draws new limits on nationwide injunctions or stand by them as a check on executive power. I'm Brody Carter, CBN News.
A pivotal case indeed. Gordon?
It is an important case, and I side on limiting the power of one district federal judge. We've already seen it. We saw it in the first Trump administration where there was forum shopping. And so let's go to a district court where we know we can get a favorable ruling based on the ideology of the judge. These are political appointments, and so political parties in power select that district judge. And so if you're trying to stop an administration doing an executive order, you go to a district judge who was appointed by a different party and you plead your case. And then if he can issue a nationwide injunction, which happened in the first Trump administration, a U.S. district judge in Hawaii enjoining the administration on immigration policy, not just nationwide, but worldwide. And where is democracy in that? If people are electing candidates who are making specific promises of what they're going to do when they're in office, and that promise, well, I can't really keep it because a U.S. district judge won't let me, doesn't really make sense. So I hope the Supreme Court limits it, but there needs to be a way to sort of fast track these cases So instead of requiring people to file in every single district, can they have a fast track so that the Supreme Court or the Circuit Court has the ability to rule on the law so that we can all move forward? Here's the strategy, and it's a very interesting strategy. You file in a favorable district, you get a favorable ruling, you get an injunction limiting the power of the executive to do anything, and then you know it's going to take years for an appeal to finally get to the Supreme Court. And in that time, there's only 4 years in a presidency. In that time, you're going to limit their power and their authority. They're not going to be able to do what they promised the electorate when they came into office. In my view, that shouldn't happen in our republic. The executive should have power to act on the promises that they make when they're being elected. If certain things are deemed to be unconstitutional, how can you then fast track to the Supreme Court to say, have that ruling, and that is in accordance with the checks and balances by the framers. But an individual district judge, I don't think they ever envisioned it that way. We'll see. In my view, this is a very important case.